Hey everyone, we are here with Rebecca and Mark. They'll be doing a talk on legal learnings from the 2007 ICO boom that DeFi liquidity miners and yield farmers should be aware of. And I'll let them take it from here. Can you guys confirm in the chat that you can hear them once they start talking?
Hi everyone, this is Mark Boron from Manatt, Phelps & Phillips. I'm a partner in the financial services group. And we are going to be covering various topics that touch on kind of the history of DeFi, as well as kind of the space in general. And I'll kind of let my partner, Rebecca, introduce herself.
My name's Rebecca Rettig. I'm also a partner at Manatt, Phelps & Phillips. Mark and I work together a lot, and we work together on blockchain and crypto, and really for the last 18 months or 2 years have focused a lot on DeFi and work very closely with a number of DeFi projects in the space, VCs, and all sorts of different actors in thinking about DeFi and regulation. So we're going to share some of our insights today. And with that, we'll share our presentation. So as Mark said, we're going to talk about legal learnings from the 2017 ICO boom it says that DeFi yield farmers should be aware of, but this is really, as Mark said, a history of DeFi. We're going to cover two big cases that have come out in the past 6 months, Telegram and Kik, and their applicability. We're going to talk about some SEC enforcement orders and staff guidance and how we should all be thinking about them in the context of DeFi, the recent BitMex cases and what they mean. And also, just to close things out, if you're a yield farmer or use any of these DeFi protocols, what you should be thinking about from a legal perspective.
So jumping into Telegram first, and what we're going to try to do is kind of get into some of the, I think, nitty gritty that'll make it hopefully a little more interesting. So, Telegram, I think we all know the background in terms of, the SaaS being sold and ultimately the decision in which the SEC successfully enjoined the distribution of grams being the tokens that were being sold. But some of the key parts of the decision, are things that we're going to walk through. So first of all, the whole concept behind the SAFT was this idea that you could separate the sale of the SAFT from the distribution of the token. And what the court in Telegram said is that really what you need to be looking at is actually the sale, all the facts around the sale of the SAFT itself and what things looked like at that time. When looking at that, essentially what the court found was like, okay, so all the investors are buying this SAFT. That's great, but essentially what's happening is they also are automatically going to get these tokens when the network is, created and deployed. The thing is that nobody's really focused on is that position is actually very consistent with what the SEC has said in different contexts. So to be more specific, the SEC has given guidance in the context of safes, so simple agreements for future equity, as well as convertible notes. And what the SEC said in that context is when you sell a safe or a convertible note, you're selling that safe or that convertible note, and you are selling the underlying equity, all at that time of that initial sale. And if you think about it, it makes sense. And the reasons for that is you don't actually have to make a new decision at some later point in time as to whether you're going to accept the equity from the sale of the safe or the convertible note. They automatically convert upon one of the events that caused conversion, usually a financing. That's the exact same thing in the context of a SAFT. And so it's not surprising that the SEC would take kind of the same position with respect to a SAFT in the same way that it did, the court did in Telegram. The next thing that is, I think, very important, including in the context of DeFi, but specifically governance tokens, is that they really analyzed the scheme as a whole rather than the token itself. And you'll actually see how it is that, the Kik court may be considered to have treated that differently. But what the court in Telegram did is it didn't actually say this token is a security. Actually, when it was specifically asked that question, it said the token itself is not the security. What it did instead is it went and it looked at what are all the promises that occurred around this. Now, the reason for doing that is because the Howey test specifically says that you look at any kind of transaction, contract, or scheme in which there's an investment of money, the common enterprise, so on and so forth. And so you actually really do have to look at what is the scheme or contract or transaction as a whole. And that's exactly what the court did in Telegram. And what it concluded was, okay, so you have this token being Gram, and it didn't specifically word it in this way, but when you combine everything, it's kind of the effect that you get is you have this token that was Gram that was wrapped into and part of a broader scheme, a scheme that included a bunch of promises, which included promises to use Telegram's efforts to build out the TON network, and then to go ahead and bring, adoption to the network, mainly obviously through, Telegram Messenger. So that's kind of the scheme aspect. On top of that, what the court kind of presented us with is this new way of thinking of the efforts of others prong, but nothing really actually changed from a legal perspective. When you look at the Howey test, that last prong is whether there's a reasonable expectation of profit based on the efforts of others. Well, that based on the efforts of others, when you kind of deconstruct it a little bit, what you're really talking about is it's based, on the essential managerial or entrepreneurial efforts of others. And the court kind of pushed that to its limits in Telegram, essentially saying, one way to look at this and one way to feel confident that you don't have efforts of others is if the entire team were to decamp to the British Virgin Islands, would you have you would have nobody there to be looked at to create any kind of expectation of profit, to grow the network, to do any of that. But the key part here is the court did not say, if you leave, the network is still going to exist. Okay, that's essentially true. Look at any DeFi project. Mostly, you leave, the network's going to continue to operate in the way that it has historically, leaving aside any bugs. What the court's really looking at is, are those who purchased the tokens or the instrument or the scheme as a whole, are they going to still get the same kind of adoption? And is the same value going to be created, even if they are not there? Now, that doesn't give you the bright line of where it is that efforts can be cut off. It's more about pushing the limits and saying, if you do get here, then maybe you are okay. And then the last part is that, you basically, when you look at Telegram kind of as a whole, what you get to is you get to this point where you basically say, okay, well, maybe you can actually issue a token where there aren't any essential or entrepreneurial efforts. Maybe there is a community that is big enough, that is truly the community that is going to go ahead and grow the network and the ecosystem from here, rather than looking at a central actor. And so I'll pass it off to Rebecca, where she can kind of talk about kind of a central actor in the form of what we saw with Kik and the Kik decision.
Yeah, thanks. So one thing I wanted to do is just back up for a second and just give a little context. While I'm sure everybody here knows Telegram and Kik, I just wanted to say they're both court opinions coming out of the Southern District of New York regarding both Telegram's sale to investors as it built the TON blockchain, and Kik's was the sale of Kin to continue to build out its platform as well. And both opinions looked at whether the sales of whether these sales constituted the sale of unregistered securities. So Mark's point in Telegram is that, they looked at the purchase agreements, which wrapped the grams as a whole, and said that sale constituted an unregistered security. And in Kik, they looked at the token sale as well, or what we'd call a token sale, and said, yes, this also constitutes the sale of an unregistered security. Kik looked and said the sale of Kin constituted an unregistered security. So unlike Telegram, it didn't talk about the understandings and agreements that wrapped up Kin to be sold, but no one had addressed that point at any of the briefing in terms of how to back up and look at the scheme. So that's one key difference. But there are a number of similarities as well, and a number of other takeaways. So the Kik, like Telegram, looked at the Howey test and said, is there an investment of money in a common enterprise where there was a reasonable expectation of profits based upon the efforts of others? The court found yes to all of those, but some takeaways that I think are applicable as we're thinking about DeFi is that there is a common enterprise when the value of the asset increases or decreases in the same way for everyone who holds that asset. So if all token holders have the ability to profit or to lose in the exact same way, there is definitively a common enterprise. The other thing that's very important is that the court found when it was looking at the efforts of others is that the value of kin itself would be driven by the ecosystem that was built up around it. And then it found that only Kik was available to build the ecosystem. But when we're thinking about these DeFi these DeFi protocols, one of the things that Mark and I think about a lot, and I'll just do the general disclaimer that this isn't legal advice and the opinions we're talking about here are our own and not that of our firm or anybody else. But one of the things we look at a lot when we're looking at these DeFi protocols is how big is the ecosystem around it? How many integrations are there? Who is building on top of it? And that is important when you think about the value of any ecosystem in general, is how many participants are there in this ecosystem. And the last point on Kik is that there was both a private sale through a SAFT and a public token sale. And while Kik tried to distinguish that point and say, no, these are two different sales and they should not both be found to be unregistered, neither of them should be sales of unregistered securities. The court found that because they were close in time and they were the sale essentially of the same thing, that this is what was called an integrated offering, or basically one offering that suffered from the same flaws. And so separating them out to be public and private wasn't enough. And that's something. Go ahead.
I was going to say this in conclusion on the integration is important, because if you have one sale followed by a subsequent sale of a security, and they're deemed to be integrated, and there's like a 5-factor test for how that gets determined that the Kik court walked through. But if they get integrated, even if you had one sale that was compliant, your subsequent sale that was non-compliant will essentially taint the compliant sale because they're treated as one. And so now you have one entire tainted sale.
Yeah. But in addition, we haven't just had these court cases. In fact, the court cases themselves are much more recent. What we've had a lot of that everyone's aware of is, about 2 years worth of SEC enforcement orders and guidance. And there we have some learnings there that we think are also important when we're going forward and thinking about DeFi and governance tokens and the like.
Yeah, and so the enforcement orders, there's so many. I think there's over probably 30 of them right now. Many of them don't give much value, but one that gets referred to a lot and that more, I think, recently has been referred to quite a bit, at least in passing in terms of never actually mentioning the name, which is Tomahawk. And basically this tracks back to the concept of an airdrop that has been used in governance tokens and that is talked about a lot. Now, if you go back to the late 90s, the SEC gave guidance on what people refer to as these free stock cases. And essentially what it was companies giving free stock. And the SEC saying, well, stock is a security inherently. It always is. It's defined as a security in the Securities Act. But what wasn't sure is that, well, to actually violate the law, the Securities Act, you need to have an offer or sale of that security. And so we went ahead, the SEC went ahead and said that when you receive any kind of value by gifting stock, you are actually offering or selling that security, and specifically selling it. And so the SEC did the same thing with Tomahawk. And the idea there was, Tom was the token, and the SEC first walked through whether Tom was a security. And it specifically concluded that Tom was a security, completely independently of the airdrop. That was not meaningful in its decision. So now we already have a security. Then what the SEC says, okay, is the airdrop was a sale because you went ahead and you gave it out, but people gave up something of value in that airdrop. those were not airdrops to random ETH addresses or prior users. Those were airdrops to those who were providing marketing services and other value in exchange for it. And so what the SEC ended up concluding is that, Tom was not registered and it was the sale of an unregistered security. Now, this ends up being quite different from when you have an investment contract, right? The analysis there would be very different, because what you would have is, let's say Tom wasn't actually a option, as the SEC said. Let's say Tom was a token, just like many of the governance tokens we're seeing now, and on a very decentralized network with a team that isn't participating much. I think what's key there is what the SEC would have to do first is analyze, is there a security? And it wouldn't say, oh, you airdropped it and so there's a security. No, it would say you airdropped it and so there's a sale. It would actually have to be an independent analysis as to whether an investment of money exists. And an investment of money requires giving up something of value, not the company receiving something of value in the same way as a sale, but the recipient actually giving up something of value, something that existed in Tom, but we don't always see that when it comes to some of the tokens that are being distributed through different governance mechanisms. And so, I think on top of that, we also have FinHub's digital assets framework. So this was essentially the SEC's, or at least FinHub's, effort to try to give more context to the Howey test. And essentially it broke it down into many different pieces. There's a few parts worth kind of talking about. The first one is this concept that, I think attracts a lot of people's attention, of active participants. I don't think, Rebecca and I don't view that as a new concept. We view it as kind of worded in a new way. But the general idea is, just because you go ahead and you ask others who are affiliated to you to do things that you could have done yourself, it's not just going to, fly and now you haven't done whatever action it is that would kind of deem so that your token wouldn't be a security because you didn't do X, Y, Z. No, instead what the SEC is saying is, if there's a small group working together, an affiliate of third parties, we're going to view those as active participants, and we're going to view them as one for purposes of analyzing things under the Howey test, including efforts of others. The second part of what the digital assets framework did was really create, I think, a pretty holistic kind of analysis. It wasn't just an analysis that looked at, okay, is the network decentralized? Is there any work being done on the network from a development perspective? It was rather focused on everything as a whole. What are the marketing efforts? Who owns tokens? What software efforts are there? That was relevant as well in terms of development. What does the community look like? It really walked through looking at kind of the efforts of others as a whole. The last part is that the concept of a digital asset kind of morphing is something that it walked through. And it's this idea that you can have a digital asset that is or is part of a scheme that constitutes an investment contract, and that at one point in time, it may no longer be. So you may choose to sell that token, and that token may no longer be part of an investment scheme. So you could imagine a situation where there's a promise to go ahead and give and provide value for 2 years. We're going to continue to develop this platform for the next 2 years. After that, we're not going to do anything anymore. Well, following that 2-year period, assuming that actually happens, that investment, assuming that was the only promise around it, that promise goes away. And now what you're left with is just a token, and that's it. And at that point, the SEC's kind of hinted at this idea that maybe you can go ahead and reevaluate whether the token is still wrapped in that investment contract, or whether now alone it is just a commodity that is no longer also a security. And so that then brings us to some of the more recent news that ends up being relevant, which is kind of the BitMex action that we saw probably about 2 weeks ago, that complaint from both the CFTC as well as the DOJ.
Thanks. So as Mark said, there were two complaints, or two big actions filed against BitMex about 10 days ago, I guess it was, or 2 weeks ago. One was a civil complaint filed by the Commodities Future Trading Commission, and alleging that BitMex, which is a centralized exchange, violated the commodities laws by not registering to be a futures commission merchant. And the other is a criminal indictment against BitMex's founders and its executives for violations of the Bank Secrecy Act, which carries with it criminal liability and thus jail time. Violations of the Commodities Exchange Act, or the CEA, and its attendant regulations carries with it civil liability, so fines, shutdowns, things like that. Whereas we talked about the liability for the BSA carries with it criminal sanctions, and I'm sort of starting from the back and going forward. But we also have some other learnings from BitMex, even though it's centralized, that I think are important to DeFi projects in general. And I'll go back to the first block, which it says, non-US entity structuring does not insulate you from liability. So one of the things that they talked about in the BitMex, in both the criminal indictment and the civil complaint, is that notwithstanding the fact that BitMex had incorporated in the Seychelles, they had basically set up operations in the United States and had offices here and conducted business here, and basically were essentially operating as a U.S. company. And for that reason, we're able to be under the jurisdiction both of the Department of Justice in the United States and the Commodities Future Trading Commission. So as you're setting yourself up, we know people both have been setting up DeFi projects offshore entirely, but potentially are still touching what we'd call touching the United States through getting investor funds, through having contractors here work on the code, through marketing here, coming to conferences here. And that in itself definitely will or may subject you to U.S. jurisdiction from any regulator or from the Department of Justice. That's important to think about, is how you set yourself up and how you structure alone is not enough. You have to make sure, if you want to be outside the US, that you're actually outside the US. And the other thing that Mark and I took away from BitMex that we thought was very interesting and very applicable to DeFi, and which we talk about a lot, is that they said the geofencing of certain users and certain countries was not sufficient in order to insulate themselves from liability or to comply with the Bank Secrecy Act. And we know lots of these of DeFi projects have user interfaces, and some may be geofencing in some ways or the others. But what we've really taken away from BitMex, and what we think and talk about, even what we've thought and talked a lot about even prior to BitMex, is that there are ways around geofencing. People this deep in technology, both on the project side and the user side, know it. And so there has to be a real meaningful effort towards, blocking certain users in certain countries, if that's really what you're going to do. So like everything, you have to really show that you mean it if you're trying to aim towards regulatory compliance, both staying outside the US or geofencing or actually complying with the Bank Secrecy Act. Meaningful effort is really important, and not just for show. And I think one of the things, we've talked a lot about what the projects are doing and should be thinking about, and what we've learned from the 2017 ICO boom and how it applies to the projects. But the other thing, especially because when we're talking about DeFi, we're talking about the decentralization and digitization of legacy financial instruments and institutions. And by doing that, as a user, you are participating in a new financial system. But that financial system has regulations that apply to it in some ways, in the same way that it applies to legacy finance, or in potentially different ways. And both participants in the legacy financial system have regulations that apply to them, and so too do users, such as yield farmers, have regulatory risk that may come along with what they do. So one of the first things that we've thought about, and that I think is important, is your participation in governance as a user. When Mark was talking about the FinHub guidance, he was talking about this concept of active participants. The way governance is being built up now, it's supposed to be intended for a diffuse group of users, let's say a few hundred, 2,000, 5,000. When you have a large group of very motivated participants in governance, you may not be subject to the concept of this active participant. But if you and 3 or 4, maybe even 10 other people are coordinating together in governance, especially at a very early stage of a governance system around a protocol, in order to build the protocol, bring value to the governance token and the like, you really need to think about how heavily and in what ways you're being involved, so you and this group are not necessarily deemed an active participant under the SEC's framework.
Yeah, and then the other thing in DeFi that isn't talked about very much that ties kind of user or participant risk is kind of the concept of providing liquidity. And a lot of these protocols, you can tie the provision of liquidity to concepts that exist, outside of the DeFi world. So, for example, in the context of securities laws, a dealer, when you look at, for example, a liquidity pool and those providing liquidity to those pools, they start looking a lot like dealers. Well, if some of the tokens being traded or part of those liquidity pools are securities, then you start having questions that arise there. The commodities laws are even maybe more problematic than securities laws because of how broad they are and the way in which they almost naturally push risk onto users. And that is that if you're holding a token that ends up being any kind of derivative, whether it's a futures swap option, those need to be traded on exchanges, referred to as designated contract markets in the context of commodities laws. Well, none of the DeFi protocols obviously are designated contract markets, and therefore these are all off-exchange derivative transactions. And subject to other limited exceptions, off-exchange derivative transactions need to be between eligible contract participants, which also involves having assets in either of more than $5 million or $10 million, which often isn't the case. There's other lending laws that exist in this context that could arise in the context of margin trading specifically. Lending laws is another issue, where you're providing liquidity. If what you're doing could be considered, providing a loan, and a regulator were to look at that and you're not a licensed lender, there's contexts in which, again, there could be liability there. And so, and using these DeFi protocols can create risk. Now, those are kind of purely kind of legal risks that exist, not necessarily risks that regulators are focused on right now, but it's something that, everyone should be aware of. I think it's worth trying to answer a few of the questions in the last few minutes that we have, unless you have anything else to add, Rebecca.
No, and we're going to answer some of the questions, but in addition, if you guys want to reach out to us at any point in time with questions that we might not be able to answer, you can do it at our contact information here. We're both on Twitter, we're both on LinkedIn, so feel free to reach out at any point in time.
Yeah. So taking, I think the first question, and I'm not 100% sure what's being asked, but general idea is Blockstack before its Reg A offering had, I think, a SAFT offering. That probably was scrutinized to some degree in connection with Blockstack's offering, but I'm not sure it's a good example, only because Blockstack ended up doing a Reg A offering, and it ended up basically it did treat its token as a security, and therefore it's not really a good example if you're not going to be treating your token as a security. I don't think looking at what Blockstack has done is necessarily, I think, the right way to go. I'm not sure what the second question is getting at. You have different thoughts, Rebecca?
I don't.
Maybe we can jump down.
Yeah, except I'll just say, I don't know what it means. Yeah, I don't know what the second one means. So what's going to stop other countries' legal bodies from making the same claims as the U.S. are doing? There are different laws in different countries. And I think to the point that Mark and I were talking about before, which is, if you are going to be operating offshore, you have to make sure you're really offshore while you're doing that. And if you're not going to be subject to U.S. regulation, you have to make sure that you are going to be complying with the regulations of whatever country you're incorporating in. And that's really important.
Yeah. And the key is there is such a huge focus on the US because the second you touch a US user, most, or US person in general, most regulators are going to say, now we have jurisdiction over you. It might not be that broad in most other jurisdictions, but there are some jurisdictions that have some pretty strict laws when it comes to crypto in general. And so it is something that should be paid attention to. If you're not going to be fully compliant in the US, which otherwise might end up causing you to, by default, be compliant in other jurisdictions.
Yeah, and one last little thing, I'll say we got a new question, which is about how could you do KYC and AML and DeFi, and how will regulatory approach this? There are a number of different things to think about, both from the level of centralization that the company has with respect to the project, whether the protocol is decentralized and how, and whether the user interface is decentralized and how. But thinking about AML and KYC in DeFi is actually important, and it's something you should definitely reach out to competent counsel to discuss.
Cool. This was a really useful session. Thank you guys so much for preparing this. We're going to transition to our next talk now. And again, thank you again.
Thanks.